So I have the unenviable task of last speaker of the afternoon. So I will do my absolute best to try to keep you all awake, because I recognize that's my primary task today. Beyond that, I'm going to be sort of taking off where Raj, he focused on the in-house aspects of strategies. Let's see if I've lost my mic. So at this point, we're going to kind of switch the focus. It's very much related to what he was talking about, but the focus at this point is going to be on sort of looking at, very much from a strategy standpoint, but looking at U.S. law and understanding the global implications and certain strategies that should be understood for global portfolios, for infringement positions, and a variety of things. Again, taking off where he left, where he was discussing this. Today we all face budget issues. There's a fixed amount of budget. The issues are even more pressing in terms of what we have to do with the amount of budget that exists. Whether you're in-house, whether you're outside counsel, it's the exact same issue. You're trying to squeeze out as much as you can. The essence of that means you have to be strategic. You have to really properly think about getting the most you can out of every single filing, doing it as strategically as possible for the advantage of your company, your shareholders, whoever it is that you're reporting to make sure that you're doing as good of a job as you can. So I'm just going to touch on a few areas. The U.S. law has gone through a sea change in the last 12 to 18 months. I'm sure many of these aspects are going to get covered this week. So I'm just touching upon a few areas that I think are notable. And to provide a little bit of background, we have, I don't know if you've seen this is the cover of WIPO just a few months back. This is very difficult to read probably for all of you. The upshot of this is essentially, there are patents being filed principally in a huge number in a variety of different jurisdictions, that is sort of a new trend today, in particular in Asia-Pac. The specific areas that they're being filed in, the sequence that they're being filed in, these are all sort of new areas. And what that means for patent practitioners is it's so much more about where you file, when you file, how you file, and what you file. It's a completely different game. I've been practicing for about 20 years, and it's not nearly as simple as it was before. You really have to think about the strategy really drives every aspect of what you do, from your initial patent filing to every aspect, especially if you think this is going to be a critical patent area, important product launch. All the more reason that you really understand the global perspectives and how they affect what you're going to do with your patent strategy. So these are the three areas we're going to talk about. One has to do with divided/joint infringement. There was a seminal case last year in the United States called Akamai that completely changed the way that we look at indirect infringement. The second has to do with the long arm of the International Trade Commission. There's a case called Tianru that we'll be covering that explains sort of the expanded scope of the ITC. And the third is there's any number of issues related to the American Inventors Act and strategies associated with that. In this instance, I'm just going to cover some of the short-term areas that I think are notable. So again, looking at indirect infringement, let's sort of set the stage so you can see the extent of the contrast. Before the Akamai case, what was required for indirect infringement was that at least one party have committed the entire act of direct infringement. So this basically comes up where you have, let's say, a method claim. There's multiple steps. Let's say the final step of the method claim can only be practiced by the end customer, for example, which is more or less the fact pattern in Akamai. So in that instance, under pre-Akamai law, there would be really no way that anybody could indirectly infringe, because the final step would be something that the customer would have to sort of execute to complete direct infringement. And then in addition to that, under different aspects of joint infringement, courts also required that the party, if there was a party, let's say, that was completing all the other steps except for the final one, they had to have direct control, they had to direct or control that final step. So it was a very limited test, very strict window of what was required and what was allowed, and hence, frankly, pre-Akamai, there were relatively few cases of indirect infringement that ultimately were litigated through U.S. courts. The other aspect has to do, so the second case is this McKesson case. It principally has to do with inducing infringement. So that's where you are, sort of collectively, you're working together. One party is inducing potentially the infringement of a final step. In that instance, again, pre-Akamai, the test was that there had to be an agency relationship, that there had to be some contractual obligation but from one party to the other party to complete that other step. Again, a very limited test, narrow set of circumstances that would satisfy these requirements. So now the Akamai, post-Akamai, the holding is that a single direct infringer is no longer needed to induce infringement. So effectively, you can now have multiple entities that in concert can come together and satisfy the direct infringement prong for inducing infringement. So as you'll see, the other very important aspect is it doesn't require agency anymore. Under the Federal Circuit specifically indicated that inducement is not needed. If you cause, urge, encourage, or aid infringing conduct, that is sufficient to induce infringement. So that obviously the sort of litmus test has substantially come down. You can now have multiple entities that, whether they appreciate it or not, are working together to indirectly infringe a patent. In the context of, is knowledge required, is there an intent requirement? It's, again, the Federal Circuit specifically indicated that this is not a strict liability tort, that it requires simply that there was a knowledge that these acts could constitute patent infringement. And so if we look at the very specific findings of the Federal Circuit in Akamai, they indicated that a defendant would be liable for inducing infringement if the patentee could show that, one, the defendant knew that the plaintiff's patent existed, that it performed all but one of the steps of the method claimed in the patent, that it induced another entity to perform the final step. So in that instance, it was actually the sort of end customer that was being, quote unquote, induced to perform the final step, and that in fact that step was completed. So you can sort of envision a whole series of scenarios under which this would take place now, especially for method patents where you've got these multiple steps. There's any number of times where the claims are written in such a way that historically they'd be written in a way where the end step would be done by somebody else so that you break up infringement. That does not help you anymore. So in terms of patent drafting strategies, it's very important that you keep this in mind, that you recognize that there's another whole infringement paradigm that exists. And so when you're writing the claims, you need to be very mindful that inducing infringement, you need to understand who your competitors are. You need to take a look at how it is you're structuring your claims, to keep in mind that multiple entities can come together. And as long as you meet these requirements of knowledge and facilitating the final step, you can induce infringement today. I would also sort of kind of caution, Akamai was an en banc case, which means that it was a very narrow majority that ultimately decided the case. It was a 6-5 decision. So it means it is law, so I'm not trying to pretend like it's not law, but there was vigorous dissent by the other 5 members of the Federal Circuit. It is likely that they will probably chip away at certain aspects of this over time. So it probably is still best practice to draft method claims where you have a single direct infringer. That is probably still the best way to go. But you want to be mindful as you're drafting, as you're coming up with strategies, that the inducing infringement is very much a viable and expanded doctrine today. The final sort of aspect that's very important to realize is that your existing opinions need to be looked at again. The basis for why you cleared something, to the extent it's a method claim, and if you indicated, if you understood that that indirect infringement was not a possibility pre-Akamai, all of that needs to be revisited in view of the new law. And I would also say, because there's this knowledge requirement in Akamai, equally there's probably an increased need to create and have available opinions, right to market, freedom to operate, whatever you want to call it, opinions that are that you can rely on to establish that you did this analysis. You understood that you either had a non-infringement position or an invalidity position, and that was the basis for why you cannot satisfy the knowledge requirement under Akamai. So now I'd like to look at the Tian Ru case, which very clearly shows this very expanded sort of jurisdiction of the International Trade Commission, which is distinct from our Article 3 judges, our Article 3 courts. So we'll kind of get into that a little bit. But this is very important as we talk about global patent strategies. What many companies sort of have this issue is when they get into global areas is trade secret misappropriation, and what happens as they kind of start to disclose some of their critical processes. How do they protect their trade secrets? This has been an ongoing issue for many countries, especially as they expand into sort of new markets. So this case, for the first time, provides some real teeth in the United States as to what you do when trade secret misappropriation takes place outside of your borders. So in Tianru, the Federal Circuit essentially allowed the International Trade Commission to exclude imports of this was a Chinese company that was essentially manufacturing these railway wheels, steel cast railway wheels, using what ultimately was found to be a misappropriated trade secret. So although the entire trade secret took place in China, the misappropriation took place in China, what the Federal Circuit ultimately decided was that the International Trade Commission had the authority to expand its reach to misappropriations that took place within China. So, this, like I said, this is sort of unprecedented. The federal district courts, to my knowledge, do not have this sort of power to date. And so the International Trade Commission has this authority to do this. In terms of the background, you should know that the fact pattern was effectively, there were discussions taking place between a Chinese company and the US patent holder. They were trying to get a license, that fell through. They went to Plan B. Plan B was effectively hiring away employees. So they hired some 9 employees that had confidentiality obligations. Over the course of, wooing away these various employees, they then, needless to say, sort of took along a certain amount of the trade secrets associated with manufacturing these particular wheels, and shortly thereafter began manufacturing and selling them. The American company filed what's referred to as a 337 complaint before the International Trade Commission, requesting that all imported goods using this misappropriated trade secret technology be blocked at customs. And so the sort of, the kind of critical aspect of this is twofold. One, that so there's a requirement for the International Trade Commission, the kind of a litmus test is there a domestic injury taking place within the United States? So in this instance, although the US company was no longer using that trade secret, they owned the trade secret, but they weren't actually using the trade secret anymore. The International Trade Commission said that the domestic injury requirement is actually expanded for trade secrets, unlike patents. And so they expanded the sort of injury requirement to allow the US company to claim injury, even though they weren't technically using that trade secret in the US anymore. So again, if you kind of look at it very broadly, you have a US company that is not using the trade secret in the US, you have a Chinese company that's never used the trade secret in the United States, and yet in the US, this American company can now block all imported goods from coming into the United States because the Chinese company misappropriated a trade secret that the US company had at one point. Still owns it, but isn't currently using it. So needless to say, this is, there's some serious teeth to this particular expansion of the International Trade Commission's abilities. So we're expecting clearly that the International Trade Commission, there's going to be a very big uptick of misappropriation trade secret cases. You should know this is a double-edged sword. Effectively, the International Trade Commission, like I said, the sort of litmus test is whether there's a domestic injury. It doesn't have to be a US company per se. There simply has to be a US domestic injury. So it's very possible that a foreign company that has a presence in the United States can establish a domestic injury against a US company that's doing the same sort of misappropriation outside of the United States. So this works both ways. It's not limited to sort of US companies alone. What I would, sort of as a result of this, I would very much caution, companies to be very careful about what they're doing. Trade secrets, for a variety of reasons, both in the context of AIA as well as this expanded doctrine, have really, sort of come alive more recently. And I think if you fully, this unfortunately is a very sort of complicated topic, but if you fully look at the depth of what's allowed through the International Trade Commission, and you couple it with this sort of expanded jurisdiction that they have, you'll understand the full breadth and why this is such an incredibly valuable tool. Sort of in a nutshell, the ITC, basically, there are no jury trials. They have a series of very sort of focused, capable administrative law judges in DC that 70% of their docket is just IP. So they're very focused and have a deep understanding of IP issues. And most importantly, the damages, they don't have the authority to have damages as remedy. Instead, what they do have, which oftentimes is even more powerful, is the ability to issue these exclusion orders that then go to customs and block all importations of either patent infringing goods and or in this case trademark misappropriated goods. So the combination of these two tools, and I'm sorry, the other prong is that in the ITC, all cases are completed between 9 and 12 months. So it's fast-tracked, you get this exclusion order, they have expanded jurisdiction, the domestic injury prong has come down, so, like I said, we're really expecting this to be a tool that people really start using. And finally, like I said, there's a whole host of AIA, the American Inventors Act strategies that exist. I'm just going to touch on a few that are sort of imminent that people probably need to know. And most of them have to do with sort of understanding the effective filing date, because that's something sort of in the next year or so people need to really start looking at in the context of your priority filings and what law actually is applicable. And this is relevant because post AIA, the sort of what constitutes prior art, the breadth of that is substantially changed. It is expanded in great scope, and so you can have very different sort of outcomes depending on whether your case is pre-AIA or post-AIA. And so that's something, again, you very strategically want to choose. And so if you have this very complicated global strategy where you're relying on, claiming the benefit of a pre-existing filing in another country, you want to make sure that you take advantage and consciously choose, are you going to go pre-AIA or post-AIA? And also recognize that there's a variety of things that take place in prosecution that will take away your ability to continue to keep that selection in place. So for example, during prosecution, let's say with the CIP, if you add a claim that doesn't have the support of the pre-AIA earliest effective filing date priority case, that will essentially throw not just that claim, but the entire case into post-AIA law. And even if you subsequently withdraw that claim, you've moved into AIA world and that prior art, and there's nothing you can do subsequently to revert back to pre-AIA law. So that's sort of something that's critical to remember. There's a series of notice provisions that the PTO is requiring because they want the patentees to put the PTO on notice when a case toggles from pre-AIA to post-AIA. So there's notice provisions that I think are very important for people to keep in mind and to be aware of. And then in addition to that, there's these grace periods that people have been talking about that the Patent Office has issued some additional sort of information about that make it clear that the grace period for inventors in the context of public disclosure is substantially narrower than what was initially understood. When the AIA was first sort of, when the initial sort of publications came out about the AIA and its scope, this was something that was lauded as being a fairly significant grace period. It turns out that it's quite limited. What's required is that only inventors have the opportunity to afford themselves with this grace period. If others, and the grace period effectively works, let's say if you have a disclosure, a year from that disclosure, if you file, you get the benefit of you get to sort of swear behind that disclosure by 1 year. That's the only sort of swearing behind provision that's left in the U.S. law post-AIA. The catch to that is there was a provision in there that made it seem that would apply to others as well. It only applies to others if they have specifically derived their invention from the inventor and/or if their disclosure is identical. So it's much narrower than was originally understood. And the other important point to remember is record keeping is critical to even establish that you have this disclosure, and that if there was a derivation, to establish who derived what from whom. So I think in the context of that particular grace period, making sure that you keep very accurate records for litigation purposes is going to be critical. And so with that, that's my food for thought. Thank you very much.